Welcome back to Palatable Politics, a show where we take the complexity out of politics and make it palatable for you. With me, your host, TJ Maslela. Welcome to the show. Today we're going to be discussing the music industry, the Performers Protection Act, and also the Copyright Amendment Bill. Here to give us insight is the president of the South African Music Industry Council, Mr. Vusi, Leeuw. Welcome to the show.
Thank you, and greetings to your audience as well.
Thanks.
Yeah.
So for some of our guests that don't know some of the talents that you have discovered, including Wandoza, TKZ, can you give us a bit of background as to who you are and some of the great guys that you've produced?
Okay. Long and short, I was born in Soweto, went basically graduated at Wits University with an industrial sociology and politics degree, and but music has always been in me, in the family, and so I was then recruited by 999 Music, after my completion, and yeah, so from there I think onwards it was my passion in discovering and enhancing talent. But also I think at that time as well, for me, it was, as a cultural activist, it was a role that one took based on the fact that, where the country was that time, which is post-94. And, you had, a number of young people who had not been able to complete their schooling, their matric and stuff like that, because of the 1985 largely political period, where we referred to it as the last kicks, of a dying horse, because that's where I think, people, there's a generation that talks of 1976. We talk of 1985, because 1985, we were making the country ungovernable.
Yeah, interesting.
Yeah.
So now, in your talent search, there's a Bulelwa there that wants to be discovered. How does she go about getting on your radar?
So, the interesting part about talent discovery, there's no one way. Bulelwa could be somebody, you could be introducing me to Bulelwa over the phone, and I just had to say, Bulelwa, sing.
Right.
Yeah, Okay. So it's that way. It could be you are at a function event, and there's a young talent, unknown, who's performing there. That could be the other way, and then there's the popular way where people will send their music, which is normally in a form of what we call a demo. For one to listen to, So for me, there's no one way.
Okay.
Yeah.
No, thanks. So guys, you heard it yourselves.
Sure.
You'll find a way. So now, in the music industry, we've seen there have been challenges, your royalties, legends dying, poor her. And one of the things that's being discussed or brought about is the Copyright Amendment Bill and the Performers Protection Act.
For sure.
Can you give us a bit of insight as to, let's start with the copyright, what it is and what it aims to achieve? Yeah, then we'll move from there.
Okay. I think just copyright in general, people will talk of the intellectual property, and that is not just only in music. It's basically anything that someone comes up with, that they own, which and it's original most of the time. So it could be either from clothing design to a business, like people who came up, for example, with an iPad, to songwriters in the music business, So and choreographers, dancers today with TikTok and all, So if you remember, there was Kwara Kwara as an example, So that's an intellectual property.
That someone can copyright and monetize.
They have to copyright and monetize because it's their own.
Okay.
So when you start seeing someone using it in an advert, as an example, where it's a party scene and next thing they are doing a kwara or any of your original dance that you created, you're supposed to be compensated.
So the bill in its current form.
Yeah.
Where are the challenges and what is it that the amendment is trying to deal with?
I think the bigger one that I'd like us to highlight is the part that talks about fair use.
Okay.
In the bill.
Okay.
All right.
Break that down.
Fair use is it's what we call not fair.
Okay.
All right. Because what fair use is saying, it says that if I want to use your intellectual property, and let's take it in a form of either it's a song or your book that you've written, I don't have to ask for permission from you. I can use a certain amount, which is then for free.
What's that amount? Is it time-based?
It's not time-based per se. In a form of a song, maybe it will say, let's say 30 seconds of your song.
Okay.
All right. In a book format, maybe it will say a certain number of pages. From, whatever number of pages, a certain number of pages, or it's a page or a paragraph that you want to use, from your work. We could use it any way we want to. We don't have to ask for permission from you.
Or pay me.
Or pay you. Both, actually. We don't have to ask for permission from you. We don't have to pay you.
So the amendment bill is, I assume, trying to address this. But there are also challenges there.
Yeah, the problem is the amendment bill in its current form is supporting fair use, which is very dangerous. Because I'll be open and be straight. Platforms like Google, they survive on people's IP, intellectual property. Because if I'm searching for something, if I go in there, I'll have different sources. All right?
Okay.
Let's say I'm doing a research. I'll have different sources. The question becomes, all that information that's in there that Google gives me when I'm doing my research, are they compensating the authors or not? So for them, so that they make more money, they feel it will help if they have what they've introduced.
That 30 seconds or that's
yeah, but it's something that they've been pushing even in America, to say, let's have this clause called a fair use that allows us to use whatever that you want to use. That includes in your song, they can take a certain part, any part, as long as that part, let's say, falls under fair use. In other words, that they don't have to pay you for that.
Does this include Instagram? When people make stories and then you can take a song and then...
It will go everywhere. Once we accept it, everywhere. Everywhere as in anywhere. TikTok, everywhere. People will use your music without having to pay you. So let me give an example of something that is happening now. It's just that I think a number of our artists don't realize that. If you're an influencer and a brand gives you their product, and maybe they say to you, play it in the background with your home radio, or even on the TikTok or Insta, you stream this particular song. All right? Remember, they know as a brand that they're supposed to pay for the usage of that music, the association of their brand with that music. All right? Now, there's been cases. For example, there's a case of, I'll be open with it because these are factual cases. There's a case of 4th Street Wine, which is a product of Distel, where they used...
I'm sure users know the wine.
where they used an influencer by the name of Miss Buntle Mudisele, all right, to to basically shoot content where she's dancing to various amapiano songs.
Okay.
All right. And so within that content, you also see their brand, the product. And at the same time, then there's a hashtag that goes with it. And there's a competition that says if you go from Miss Modisele's page, if you go to the brand's page and you click like, you stand a chance of winning a certain amount of money and their product. So basically that's advertising where you've used, and they were using popular songs. So you've used an artist's music as a brand to push your own campaign, and you're not paying them. So what they did then, when we approached them, they tried to make an excuse of saying they, as a brand, they were not involved. All right. Instead, the influencer is the one who was involved in using that music. But it was, but you still benefited. So, I mean, like you would know, in any case, there'll be a first of a respondent and second respondent. All right. So they're both infringing. They reposted this stuff as well on their own platform, and they were paying for the campaign. So that means whatever that was being posted, they approved it first.
Yes.
So they cannot be playing ignorant. All right. But now there's artists' intellectual property that is being infringed by a big company like that. All right. And so the long and short of it is that they thought they can get away with it. So in America, there's been over 4 cases of an energy drink that did the same thing. And Sony Music, Universal Music, forgot the other company, they took that company to court. So what they also did when Sony, when these companies made this brand aware, they started doing a takedown quickly
of
deleting. Yeah, but technology.
Yeah.
So
there.
Yeah, so in the front is deleted, but the back end, so they went and got the back end, and the case. I must say that the in both cases, or the 3 cases, the music companies won and sued that. So we're hoping that in this country, Distel, and I know it's been sold now, but a case never dies per se. So these artists will be properly compensated. But if this so-called fair use was to be passed, then artists are going to be exploited even more.
Okay. So we've discussed it and how it is currently.
Yeah.
How do you want it to be seen? How do you want it to be changed?
They have to remove the fair use. The old clause that has always been there. And
replace it with?
There's a current clause the phrase, that has been in as part of the original
the original act.
Yeah. We're saying that they must not change that part, because what that did is what's been the precedent. All right, that says if you want to use my work, you come to me, you approach me, and you can state your case. If you don't have money, you will say, I don't have money, and I will decide if it's towards a good, contributing towards a good cause. Let's say it's blind students, they need to access my book. I will then say yes, and I'll support that. But if it's my music, I will support that, But you would have respected my intellectual property by understanding that you have to come to me, and I have the right to say yes or no.
And then the Performance Protection Amendment Bill.
Amendment Bill. That part is one, the challenge is the fact that these bills somewhere along the line, they use vague words. For example, a performer in arts, the interpretation is so vast. All right?
Doesn't that mean more people get protected?
Not necessarily. First, it creates confusion.
Okay.
All right? That's why it's as if there's a fight, because you have actors saying, pass it the way it is. Okay? But you have the music side saying, no, but you cannot generalize. All right? Because when in the music industry, the word film would normally be referred to use in terms of using like the shooting of a music video, which is a 3 minutes, 30-second film.
Yeah.
All right?
Okay.
Audio visual.
Okay, yeah.
Right?
I get it.
And it's used for a different purpose. It's more from a marketing point. All right? But now it's all film. So the performance amendment amendment bill, all right, uses the word film to say any performer in a film has certain rights. Those rights are whenever that film for example, is rebroadcast, they must be paid. All right. Now, in a music video, normally, the budgets are not the same as in a film. So what people would call extras in the music video, we don't really refer them as extras. All right. And sometimes you just call anyone. All right.
Yeah.
They are not professional and all of that.
Yeah, just call your friends, come, let's.
Exactly.
Cool.
Yeah. And sometimes you have maybe a shot where somebody's passing, So that means you have to pay those people. You have to find them. Even if it was a makoko just passing or enjoying your music, I'm sure you've seen some scenes where people are in a taxi maybe, So it means for music videos, we have to pay each and every person. And when there's rebroadcast of that, let's say 5 years later, all right, they can claim. So we understand what the bill is trying to achieve, but it comes from the film industry point, which is the movies, soapies, all of that, where the actors there, whether they are extras or, it's expected that because that film might be played or sold in different places, whether if it's a South African TV channel, they might sell it outside South Africa, or it could be on some of these digital platforms that I don't know now. So, credit per se for now. Yeah,
okay, so I understand the issue there.
Yeah.
What should it be?
It should not be painted with the same brush.
So
the definitions should
section 1.1 film, section what music.
Exactly, for music. And this is how this will apply in the film industry. I don't know if it makes sense.
Yeah, no, I understand it.
Or else we're going to end up with a music video in this room, where it's just the artist and they have to dance, do everything, one man, and
Okay, there is a bit of an argument that maybe the extras in the music video should also be paid.
Yeah, but it differs.
Yes, yeah, because sometimes it is just my friend.
Exactly, yeah.
And then podcasts.
Sorry, another thing is they're also maybe not professional.
Yes, okay.
Because some of the extras are up and coming, aspiring actors, all right, who feel like maybe this is their way in first, But it doesn't mean that even in music industry side, we never gave platforms to some people who probably used the music video or were seen in music videos, who end up maybe being recruited, whether for adverts or for other films, by the film industry.
Podcasts, where do they fall into this?
That's the thing. I think we have not really looked at it from that point. I think all of us. I think because it's new, the fights have been more on what has always been there, which is the movies and the music videos. All right, but in reality, is we have to be looking even at podcast situation. But I want to believe that the podcast would be governed by what governs, let's say, other news platforms, whether it's TV news, because it's almost similar. It's a very thin line, but like I'm here for an interview, I could be going to a TV channel for an interview, So the rights there are a very thin line that says, if you repeat, does it mean that now you must pay me? Well, I mean, I'm sure a lot of us will want to do the interviews all the time. Exactly. Hoping that every time, and put it in my will, to say, my kids, I was in these interviews, so make sure that you collect the money whenever you see my face there. Sure. Sorry, but I think it highlights how these bills cannot be just looked, in the same way across the board. Each part is so complicated that it needs to be given its own individual attention.
And what needs to happen? What's happening now? What's
right now? It's a big challenge because, look, I mean, we feel that certain companies who benefit out of using content and free content have gone around and paid people to first, and some of the people are so-called celebrities, actors, singers, who don't understand. Some of them don't understand the dynamics, but some get told, this is what we're fighting for, and then they get paid. Times are tough when somebody's going to give you 10,000, and you're not getting any gigs anymore and all. It's between being true to yourself or your stomach.
So for our viewers there, the next double HP.
Yeah.
One, how do they get involved in terms of making their contribution? And two, where do they send a demo?
Okay. But first, I would say, especially, there's something that I highlighted in one of the workshops where around the bills, where every time people say record companies are bad. Now, what the let's say the legislatures or politicians, they also come from that old school. But through digital, a record company is anyone who owns a master. So what does that mean? Today there's bedroom studios and you can, after recording your music, you can put it out there. You don't need a record label per se, all right? So you own your masters. So if the rules are changed about record companies using the old mentality, that means you as a record company,
as an independent,
you're going to be affected, because it's not going to say it's not the animal farm where some animals are more equal than the others. It will just say record companies. It won't say but independent record companies needs to be treated differently. Which means even if you take your own friend or sister and you start recording them, then where do they fall? If they're falling under your company, now you are a record company as well that has an artist.
That now must pay your sister.
Look, what I'm saying is it has to be done correctly and everything, but it must not be from a mentality that again says all record companies are exploitative. So it needs to allow the development of independent record companies, you know, so that the rules are, yes, to avoid exploitation and to make sure that everyone get what is due to them, all right? But it mustn't crush the so-called record companies, because in the past, everybody says, I've been exploited by a record company and all of that. And at the same time, some of these cases have not even been looked closer in terms of when you got the contract, did you take it to consult? And people will say, but I can't afford a lawyer. But if you go to law school, let's say if you go to Vets Law School, there's a law clinic that will help you for free.
I didn't know that.
Okay.
Thanks for
Yeah.
that.
You know, law schools have law clinics where your third year or like final year students, that's where they start practicing on various legal issues, you know. So they help people who earn below a certain amount, which means they cannot afford. Yeah. So that's where they can go. I mean, there's been there for years and years.
Okay.
Yeah.
No, thanks for that.
Yeah. Also, another thing I say, why don't you go as an artist? Why don't you go to the newspaper that you normally go to when you are now 5 years down the line, you're saying you were exploited? Mm-hmm. Why don't, when you receive a contract, go to that newspaper company, you know, and say to them, I can't afford. I'm an artist, just got offered a contract. I can't afford a lawyer, but you guys have lawyers inside. Can you get your lawyers to read this for me? Help me with this contract before I sign it. Rather than you sign the contract, then you go to the newspaper to go cry. And the only thing that you're helping them with is to make money, because they're going to blow your story up, but you still have to go to court to prove that, you know, and you may still lose.
Okay. So back to the, how do people find you?
Yeah.
Get involved.
All right. Look, I think I'm very accessible. I'm on Instagram as Leeuw Vusi. Okay. All right, at Leeuw Vusi.
We'll add it for you guys.
And my email address, which is, you know, vusileeuw@gmail.com. I'm there. Why on my Insta? I'm also on Facebook. So why a lot on my Insta? Because there's a flyer that's there amongst the photos of some of the stuff that I do. And it also has my WhatsApp number that I don't know off by heart. Okay. Yeah, that's why I'm not mentioning it. But it's all there.
Okay. No, but thank you for coming through.
Thank you.
We'll reach out again once there are developments so that you can keep us up to date.
Yeah.
And we'll take it from there.
Yeah. We just are appealing and pleading to the government to make sure that the fair use part doesn't go in. The rest can, you know, the bill can move, but this one is going to destroy the industry. Already in the US, there's a number of cases that I can share with you, you know, of where people are going to court who are fighting against fair use. That includes fine artists, because remember, I can go to your studio or wherever you're displaying your artwork, and I take a photo. So those rights are being infringed. Okay. But I can use it for my own campaign, maybe, using that fair use part, and I don't have to pay you.
Okay. No. We'll definitely reach out to the Minister of Sports, Arts and Culture and just have an engagement with them.
Yeah, and also because the department that's more handling that is DTI.
Oh, it's DTI.
Yeah.
Okay. No, we'll reach out to them too.
They are the ones who must make sure
that
it doesn't happen.
Okay. No, we'll reach out. But guys, thank you for tuning in. Tune in next week. Don't forget to follow, subscribe, share, like, and all those things. Thank you. See you again.